Good morning everyone, my name is Kevin Price from the Thomas Carroll Group, and first and foremost I'd like to take this opportunity to thank you for joining us this morning for our webinar entitled The Challenges of Making Redundancies. As you may know, within Thomas Carroll we have a specialist employment law team, and we work in partnership with many businesses across all sectors to ensure that their employment law challenges are dealt with effectively. This webinar is therefore the next in a series of webinars that we have delivered throughout the pandemic to help businesses navigate through these difficult times. As the government support for business comes to an end, unfortunately for many, redundancy will be the only option. So the purpose of this webinar is to take you through the redundancy process step by step and to highlight some of the main pitfalls that should be avoided. Our presenter is Roger Davis. Roger heads up our employment law team and is a barrister with over 20 years experience, so he is very well placed and has the expertise to guide you through the subject. The webinar is pre-recorded and a copy of the slides will be sent out to everyone within the next 3 to 4 days. Also, if you have any specific questions following the presentation or would like more information on how we can support you and indeed support your employees and the well-being of your employees during these difficult times, please contact us on our email address, which is hello@thomas-carroll.co.uk, and we'll get back to you as soon as we can. Once again, thank you for your time this morning, and I sincerely hope you find the presentation useful.
This is Roger Davis, Employment Law Director of Thomas Carroll Management Services, and today I'm going to be talking about managing redundancies. Unfortunately, the economy as it is with the COVID crisis has meant that many employers have had to face redundancies and implementing redundancies within their workforce. With the furlough scheme coming to an end over the coming weeks, there may be a further requirement and indeed an increased requirement for redundancies within the workplace. The first question, of course, is to consider what is a redundancy situation. All too often, employers will describe a situation as being a redundancy without having given proper thought to the statutory definition of a redundancy, and then if they're unfortunate enough to end up in an employment tribunal, they're on the back foot trying to justify that indeed a redundancy has occurred. So what is a redundancy situation? The fundamental question before progressing. So a redundancy situation is where the business, for the purposes for which the employee was employed, ceases, or the business at the place where the employee was employed has ceased. Alternatively, there is a requirement for the business which is such that the work the employee was employed to do no longer exists, or that the particular kind of work that the employee carries out is no longer needed in the place that the employee works. So as I say, the starting point there is to ensure that the proposed redundancies do actually fall within the statutory definition of redundancy. We'll come on to collective redundancies in a moment, but just to recap on that definition of redundancies, the most obvious example, of course, is where a place of work closes. So, for example, it goes into liquidation. Another example may be where the business itself does not close, but one of its branches does. So, for example, the Cardiff branch of a particular business is closing, whereas its Swansea branch and head office is continuing to trade. The other, perhaps more likely scenario is where there is a restructure or a change within the business, which means that there is less work of a particular kind for particular employees. So, for example, you may have 2 accountants and the company introduces some new software. By introducing the new software, that work can be carried out more efficiently, and as a result of that change, there is no longer a requirement for 2 accountants. Instead, with that technological change, the work can now be undertaken by just 1 accountant. Overall in the business, the amount of work is the same, but there is still a requirement for there to be less individuals to carry out that work because of other factors. We'll no doubt come back onto that as I go through the presentation. The next fundamental question is whether the proposed redundancies amount to collective redundancies or individual redundancies. If there are 20 or more redundancies proposed at one establishment within a period of 90 days, then the employer is required to adopt the collective redundancy procedure. It's a whole topic on its own to talk about the collective redundancy process, but in very general terms, if there is a trade union recognised, then the employer will need to inform and consult that trade union with regards to the process and the proposed redundancies. If there is no recognised trade union at that particular location, then the employer will need to take steps to organise a secret ballot to appoint elected representatives. The HR1 form needs to be completed and appropriate notice given to the government department, and there are other requirements with regards to providing certain information to the elected representatives or the trade union. All in all, the requirement in respect of the process for collective redundancies is far more onerous than dealing with individual redundancies. Not only will an employer need to consult with the elected representatives, they'll also need to consult with the individuals as well. Failure to properly adhere to the consultation process and the collective redundancy rules means that employees are, if they're successful in bringing a claim, entitled to a protective award of up to 3 months' pay, and that may be in addition to compensation for unfair dismissal. So for certain, given the numbers involved, the financial consequences of getting it wrong for an employer can be quite considerable. So just picking up on the points I raised earlier, these are some of the examples which I just spoke about and gave examples. One of the mistakes made by employers around this question mark of diminishing need is failing to focus on the requirement for employees to carry out a particular type of work. So there has been plenty of case law which has looked at the question of whether there needs to be less work within an organisation in order to trigger a redundancy process. And the case law, by and large, has said that the requirement for there to be less work relates to individual roles and not there being less work within the organisation as a whole. The other point to actually consider, and this is something we'll pick up when we talk about the redundancy pool, is that when you're looking at an individual and the question of whether there is less work for their role, what we are looking for is the work which they actually carry out and not the work which is referred to in their contract of employment. So as I say, I'm not going to talk about collective redundancies in any detail today, but most employers, if they're facing a redundancy situation, are probably going to fall into the category of the redundancies being non-collective, in other words, individual redundancies. The first step in any redundancy process is to always remember that the terminology at the beginning of the process is that the employee or employees are at risk of redundancy. Employers quite often fall foul of the process by giving the indication to the employee that a final decision has already been made. The whole point of a consultation process is for the employer to keep an open mind, to take on board suggestions with regards to proposed redundancies and how to avoid those redundancies. And it is a fundamental error by an employer to start talking that redundancies are set in stone and that the decisions have been made. So, as I say at the very beginning, what we're talking about is redundancies and the fact that employees are at risk of being made redundant, and at that stage, no more certain than that. The next question is to consider the redundancy pool. So, a redundancy pool is the pool of employees from which the redundancies will occur. So, if I come back to my earlier example of two accountants, and one of them is at risk of redundancy due to the introduction of some new software, some new technology. The process that the employer would go through would be to consider which area of the business will there be less work for. In this case, it's the accountancy software, so therefore it will be the accountancy department. And the correct redundancy pool in that regard would be the two accountants, and the employer needs to make the correct decision by not widening the pool too far. So, for example, putting into the redundancy pool your non-accountant administrators. Equally, it doesn't want to narrow the pool too much by just placing one of the accountants into that pool. So what the guidance and case law says over the years with regards to who to put into a redundancy pool. For a fair redundancy pool, it needs to consist of employees who are doing the same or similar work as the group from which the selections are made, whose skills are interchangeable, if appropriate, who have the same roles but work on different shifts and carry out similar work, and, again, if appropriate, who work at separate sites. Clearly, with regards to the last example, if the one site is in Aberdeen and the other site is in Cardiff, and the particular loss of work is in Cardiff, then it would be unreasonable to include the Aberdeen site. So to take from this slide, the obligation on the employer is to apply its mind to what the correct redundancy pool is. Quite often, there will be a number of options which an employer might take with regards to pooling employees, and there may be 2 or 3 options, and a tribunal might say that any one of those 3 is right. So in other words, quite often there isn't just one answer, there are multiple answers. But the important thing here is that the employer can demonstrate that they have applied their mind to the redundancy pool. I would also say that the important thing is that the employer has consulted the employee over the redundancy pool, and also that the redundancy pool ultimately falls within a reasonable range of responses. In other words, it might be option 1, option 2, or option 3, which all look fairly reasonable, but it can't be some ridiculous redundancy pool which no other employer would ever come up with. The question will be, is a selection criteria always required? So you have your redundancy pool, you've identified who is in that pool, and the question will then be, how do we select the employee or employees from within that redundancy pool to make redundant? And the question of whether a selection criteria is always required, the answer will be no, because it will depend on the circumstances. Therefore, if we have 2 people in the sales department, and we are looking to make 2 people redundant because we're looking to do away with our sales department entirely, then no selection criteria will be required, as there are 2 people in the pool and 2 people are proposed to be made redundant. However, back to our accountant example, if there are 2 accountants and we're looking to make only one of those redundant, then we have to have a mechanism for deciding which one of those will be made redundant. And in that scenario, a selection criteria will be required. So, what constitutes a fair selection criteria? Number 1, it needs to be measurable. There needs to be a reason why the manager who is scoring the employee or managers has come to the score that they have. How have they arrived at that decision? So for example, if you had in a retail setting and you were looking to make redundant employees who were sales assistants, so the individuals who stand on the shop floor and approach customers. If you had a selection criteria which included disciplinary record within the last 12 months, that would be easily identifiable, it would be measurable, and you would be able to quickly identify what the score was in that regard. However, if you had a heading which said keenness, how keen was that employee to approach a customer? that would be a very difficult heading, a very difficult criteria to score an employee, because it's unlikely that the employer would have the information to do that, and it would be a heading which could be easily argued by the employee and challenged. So my advice would be to keep those headings simple. Make sure that they are objective as far as possible, so they don't rely on manager's opinion. They can be evidenced by paperwork which will be able to demonstrate why that score was arrived at. As I say, closely linked, they'll be defensible, they'll stand up to scrutiny. They also will be non-discriminatory, so care needs to be taken with regards to the Equality Act. So those employees who are covered by the Equality Act with regards to disability, the employer may not be able to rely completely on their absence levels, because there may be a requirement to apply a reasonable adjustment to that in order to avoid a claim of disability discrimination. So that also needs to be considered. So, popular selection or particular selection issues. Last in, first out. 20 years ago, that was a very common selection process. There was nothing else. It was simply whoever was last in was first out through the door when it came to redundancy. But of course, the difficulty with that was that it took no consideration of the skills or the expertise which the employer needed to keep post-redundancy. The opposite of that would be first in, first out, so those with the longest service. Length of service criterion, so this question of how long an employee has been employed for. There is a question mark around this and whether it is age discrimination. So it stands to reason that in order to have 10 years service, an employee is always going to have to be, let's say, at least age 26 or older. It's fine to have length of service as one heading, but it should not be the only heading, as otherwise you may find yourself on the wrong side of the law with regards to discrimination. The other consideration is attendance, and again, you need to ensure that you discount maternity leave, parental leave, etc. The other thing I don't mention on here, but which comes to mind, is if you have a part-time employee, you need to prorata the scores to ensure that they are on a level playing field with regards to full-time employees. So, once you have applied your selection criteria, what if there is a draw? So you'd go through the process, you would hold probably 3 meetings with your employees where you would discuss with them and consult with them the proposed redundancy and try to find ways to avoid that redundancy or lessen the numbers to be made redundant, or to lessen the impact on the employee if the redundancy cannot be avoided. So what if the employees are in a selection criteria, in a selection process, and there's a score draw? So 2 things. One is you should consider how you're going to deal with that prior to embarking on the process. Let the employees know, as part of that selection criteria, what will happen if there's a score draw. And whilst there has been some case law around whether using length of service as a score draw is age discrimination, I think overall it's a low risk option with regards to identifying the lowest scoring employee and identifying that individual or individuals who are due to be made redundant. So we talk about a typical selection criteria. What would we include in that scoring process? So typically we might have attendance record, disciplinary record, length of service, skill and knowledge, ability, flexibility, and qualifications. For each of those, you need to consider, do you have the evidence to back up why particular scores under those headings are given? So for argument's sake, if you're going to give a score under attendance record, that's going to be quite simple, presuming that you hold attendance records as part of your HR system. Same for disciplinary record and length of service. With regards to skill and knowledge, then that may well come down to, in some sectors, in terms of training records, certificates, qualifications. But also it might come down to performance appraisals and the fact that there has been a history of performance appraisals, and those appraisals have either scored positively or negatively an employee around some of these headings. The other thing I would say is that ideally 2 managers should independently score each employee in order to try to avoid any problems with regards to challenging those scores at a later date. So, what needs to be provided to employees? What information? There's a requirement to inform employees of their own score where there is a selection criteria. Why? Because they need to be able to effectively challenge their scoring, and of course by their scoring their selection for redundancy. My advice would always be to score the employee whilst they're sitting in front of you, as this gives an opportunity for the employee to challenge their scores and either agree or disagree with their scoring before they know whether they are the individual who is likely to be made redundant. Employees are far more likely to be cooperative with regards to their scoring before they know whether they are the one who or ones who are likely to be made redundant. As a general rule, there's no need to inform the employee of the threshold for selection. So in other words, if the score is out of 100 and those with a score under 41 are made redundant, typically there's no requirement to tell the employee that. However, there is a potential argument that if the employee in question is very close to that threshold, then they ought to be told that they are close to that threshold, and that may be the exception to that general rule. The other point to note is that there's no requirement to inform that particular employee who has been selected for redundancy of the scores of other employees, but bearing in mind, if the matter ever does get to an employment tribunal, then you may end up having to disclose that information. Coming back to earlier comments, the fundamental principle of a fair redundancy process is that there is a requirement to consult. Unless an employer engages employees in a consultation process, it's unlikely that a redundancy will be found to be fair. So, what areas should be consulted over? Typical areas of consultation are the redundancy pool, which we've spoken about, the selection criteria. And the other point to note here is that if the company has previously used a selection criteria in previous redundancies, then unless you have a good reason not to, you need to probably stick to that tried and tested selection criteria. You also need to consult with the employees over how to avoid redundancies, how to lessen the number, how to mitigate the effect of the redundancies, and another very important point which employers quite often look past, and that is the requirement to consider alternative employment. If after having gone through your, say 2 or 3 meetings over perhaps 2 or 3 weeks as a minimum, with regards to the redundancy consultation process, you're still unable to avoid the redundancy, then redundancy will need to be paid. The redundancy calculation is currently capped at £538 per week. It's non-taxable, of course. The number of weeks payable will depend on age, length of service, and on top of the redundancy payment, there will also be a requirement to pay notice. The calculation for notice is 1 week for every completed year of service, up to a maximum of 12 weeks. A failure to properly undertake a fair redundancy process can amount to an unfair dismissal, which, if it's pursued to an employment tribunal, can result into an award for each employee of a year's pay plus some other compensation on top, which I won't go into in any detail at the moment. But the point to take away from it is, if you're looking to implement a number of redundancies, then by the very nature, the fact that there are a number of employees who could potentially bring a claim, then those multiples will soon add up, and the employer is potentially at risk of a considerable financial setback if an employment tribunal finds against them. Clearly, my presentation today has only given a very, very brief overview of the process, a very, very brief overview of some of the requirements and processes and procedures around making redundancies. I would urge all of you, if you are considering redundancies, to consider taking appropriate legal advice to ensure that you stay on the right side of the law. Many thanks for listening to this webinar. I hope that you found it of some use. Thank you very much.